Today's question comes from Cuba City, Wisconsin, and the reader asks the following. When a warranty deed indicates this conveyance reserves a life estate for the grantors, how does sale of property work? And the reader says, my parents' 2006 estate planning included deeding their home to us 6 children via warranty deed with the idea that they would continue to live there. My dad was moved to a nursing home in January of this year. Mom has since passed away. Us children recently sold the property. It was our understanding that the proceeds would only go to us 6 children due to the estate planning. 25% of the proceeds were made payable to our dad. This defeats the purpose of the estate planning, as now it will go to the nursing home. Was this transaction completed properly? So this is a complicated area. You've got a lot of things going on here with Medicaid planning, it looks like. But in general, if you transfer a life estate, what I should say is if you make out a deed and you reserve a life estate to yourself, that life estate owner still owns an interest in the property. So when you went to sell it but your dad was still alive, they're going to calculate his ownership interest in the property according to his age and life expectancy. And they're going to use tables available from the Social Security Administration because they average out how long people live based on their date of birth and current age. And then it sounds like, assigned him 25% interest in the property when you sold his life estate. And if he's currently receiving Medicaid and that cash went into his name, you're right that it's probably going to count against him for receiving Medicaid. Now there's some ways you can put that into a special needs trust, but you need to do it all in the same month he would receive the property. So if this already happened, it may be too late. But for my other listeners watching, keep that in mind. But in general, before August 1, 2014, using life estates was a more common method of Medicaid planning. Now I generally don't recommend it because the state of Wisconsin has now said they're going to recover against life estates after August 1, 2014. So in your situation, I think you would have been better off with a trust planning, which possibly could have allowed your dad to live there, but the trust would own the home. And then if you had to sell it, the proceeds from the sale would go into that trust as well. Again, there's a 5-year Medicaid look-back period for that kind of planning. But it appears in this situation, if he kept a life estate, it's correct that they would have to pay him for his interest as the life estate holder when you sell the property. And in this case, it sounds like that worked out to be 25%. So great question, and thank you for asking.